but I believe I checked with you that it was okay to enter.
Okay, I'll let me have a look at that after,
Thank you.
after our class.
Yeah, yeah, no problem.
Thank you. Okay, I guess we could begin.
Hold on, Manjo, just before you begin, can you answer my question?
Go ahead. Yes, if I could. Depends on the question.
Yeah. Look, how about an extra half a mark for my assignment? Just half a little mark, mate. Just half a little mark. Why? Yeah. Because then that takes me to the next level of grades. That's why.
Oh, well, you don't have the final grade yet, so you can easily accumulate more marks.
Okay.
The second half of the online discussion or the final assessment. So that shouldn't be a problem. I mean, you don't have the final grade yet, so you'd have sufficient opportunity actually to increase the marks that you have if you're aiming for a better grade.
Yeah. But don't give Peter. Peter doesn't want any. He was telling me earlier in the offline chat that he wants you to take some of his marks, Wayne, distribute them out nice and easy, nice and even.
Yeah, I wish I could do that. Brad, yes.
I've got no complaints, mate. But I realised that you changed, the date of the exams is 17th. Are you aware that succession law has an exam on the 18th during our 36 hours?
It would appear that in the course profile, I'd actually stated that the final written assessment for our course would actually be released on the 17th. And I made a mistake in my first email when I said that it was going to be released on the 18th. And one of the students called my attention to it, that under the course profile, the assessment was meant to be released on the 17th. So because it's in the course profile, the final assessment has to be released on the 17th. Yeah. But having said that, I'm actually open to the idea of increasing the period during which a student can answer the final written assessment, our final written assessment, if that student has an exam, it's another final assessment at that time.
Okay.
So, if you send me an email because you say you have an exam in succession, I wouldn't mind giving you a longer period of time to answer the final written assessment. And that will apply to everyone else.
Okay. Thanks for that, Manjo. Appreciate it.
Okay, so any other questions? Yeah, I'm not going to change the dates, Maggie. So I'm not changing the dates. But I'm open to extending the deadline for others. Oh, there's an exam for evidence. In fact, for those of you who might be taking contracts as well, the release of the final assessment for contracts will happen on the 17th itself. I didn't realize that I had set those two dates at the same time. Yeah, okay. Well, I wish I could do something about it. The most that I can do is to extend the deadline by another 24 hours, but that's it. Because this is meant, the final written assessment is meant to actually be taken within a 3-hour period. So, if you have about 36 hours, it should actually be doable, even if it were actually done, within the same day. But as I said, I'm prepared to extend the deadline by an extra 24 hours for those who have other final assessments that will be happening during that time. Okay, so we could probably begin. So tonight we're going to be discussing the notion of Wednesbury Unreasonableness. And after studying this topic, you should be able to discuss and explain unreasonableness, illogicality, and irrationality as grounds of judicial review, and the requirements to establish unreasonableness as a ground of judicial review. Wednesbury. Sorry. So it should be Wednesbury. Thank you. Thank you, Audrey. I stand corrected. So that's Wednesbury. Okay, good. I learned something. Yeah. Somebody should have told me that a long time ago. I've been saying it wrong.
Actually, Brad told me that.
I'm sorry?
Brad told me that. So.
Oh, okay. So, yeah. So thanks for telling me that. Wednesbury. Okay. So let's begin with the first tutorial problem. Can I get a volunteer to read the tutorial problem for us? Volunteer.
I'll volunteer.
Who was that?
Sarah.
Okay, go ahead, please.
Cornelius James, a senior manager of the Department of Social Services, the DSS, was fired from his job after the DSS investigative panel, the DSSIP, found him to have committed sexual harassment against Jill Lockworth, his subordinate. The disciplinary proceeding against Mr. James has been based on the Public Sector Ethical Standards Act, which prohibits sexual harassment. Mr. James asserts that the penalty of dismissal was imposed is totally unreasonable and irrational, considering that he has been in government service for more than 20 years, always had sterling performance reviews, and was at no time the subject of any disciplinary action or investigation. Given that it was open to the DSSIP to impose a penalty such as a suspension, it was totally unreasonable and irrational for it to have imposed a penalty of dismissal. Advise Mr. James on whether the decision met the Wednesbury Unreasonableness standard of judicial review.
Thank you. Thank you, Sarah. So can I ask everyone to post his or her answer in the chat box? Would the decision meet the Wednesbury unreasonable standard of judicial review? Okay, so from B, low chance of success. Depends on the seriousness of the sexual harassment. So this is from Maggie this time, from Margie. Not met, the justification is plausible, no obvious capricious use of power based on the facts or unjustified unequal treatment. Okay. Okay, so we've got enough answers there so far. So let's look at the facts. Let's go back to the facts now. James is asserting, so this is his assertion. So Mr. James is asserting that the penalty of dismissal is totally unreasonable and irrational, considering that he had been in government service for more than 20 years, always had a sterling performance, and was at no time the subject of disciplinary action or investigation. So given that it was open to the DSSIP to impose a penalty, such as a suspension, it was totally unreasonable and irrational for it to have imposed a penalty of dismissal. And therefore, I would like to address that point that was raised by one of you, who is saying that it depends on the seriousness of the sexual harassment. So let's assume that the act of sexual harassment wasn't really serious. Is there such a thing as far as women are concerned? Or are all acts of sexual harassment serious? Or are there some which are less so? I mean, let's just begin with that, because for all I know, you can't really have different grades of sexual harassment. They're all one and the same. They're all serious. So I'm getting a comment here from Libby. Everything is serious. Brad, what do you think? Do you agree that all forms of sexual harassment are one and the same?
Okay, I was the one who put that there.
Yes.
But dependent upon what the DSSIP's rules were pertaining to that. So someone could make a sexual harassment charge under some HR provisions, pursuant to having, told a sexually oriented joke. And then you can go to the other extreme where obviously he'd manhandled someone. So, you know, it's how wide is the scope of this sexual harassment complaint, and then did it meet within the guidelines of the HR's provisions as to, you know, was it actually sexual harassment, or was it someone who has used the sexual harassment provisions to bring about a malicious complaint about an employee? Because she was a subordinate, so she might have been looking for a promotion, get rid of the opposition. So, but yes, I agree. There's no, I mean, sexual harassment is a serious situation, domestic violence, all those sorts of things. But having seen how far people take the provisions of the Domestic Violence Act, you know, I've seen it from one extreme to the other.
Okay. Good point. Now, Audrey is making the point that, Brad, you seem to be, no, where was that? You seem to be talking about the merits of the decision. So what is your response to that? And Libby is also saying you can't consider the merits of the decision. What is your response to that?
I concur.
So are you vacating what your earlier point was? I was actually convinced for a while there. So do we leave it at that? So let's go back to your point. Let's just follow that for now. So it would seem, and maybe I'd have to beg to disagree with some of the ladies there. It would seem that there are different kinds of sexual harassment, some of them perhaps minor and some which are egregious. As Brad pointed out, it's possible that a sexually oriented joke might constitute sexual harassment, but it's probably going to fall in the lower end of the scale, as opposed to one where the woman is actually manhandled. Let's begin with that. Would we be in agreement as to that, that point, that not all acts of sexual harassment are the same? Some are more egregious and more abominable than others. So yes, we could probably concur on that. Okay, good. Now, so, yes.
Sorry, this is B. I think are we not focusing on the wrong question? The question is not what sort of act he actually committed, but whether that decision is something that fulfills the unreasonableness, the decision that's made by the investigative panel. I was thinking that this is a serious decision, not that this is not a serious act that what he had committed, but that the decision that the panel made had serious consequences for Mr. James. We're not here to figure out whether what he did or didn't do. We're here to see whether the decision-making process of the panel was manifestly unreasonable.
Good point, B. Any comment to what B has just said?
I think going back on the point whether it was a merits review, having chance to consider it, we wouldn't be seeking to introduce new evidence, but what was the basis of the evidence that was put forward pursuant to the complaint that brought about the decision?
Okay, we're not addressing merits review at this time.
No, that's what I'm saying. We're not bringing new evidence in.
Yes.
We're not bringing new evidence. We're saying, so what I'm sort of alluding to is to say the plausibility of the decision, what was the basis of that decision?
Okay, so the way I would frame it with this would be this, and this is related as well to what had been pointed out by Libby, both Libby and Audrey, that we seem, when we raise that point of different kinds of sexual harassment, we seem to be touching on the merits of the decision. And so we go back to that question, is it actually relevant to determine whether or not, to look into the factual circumstances that constituted sexual harassment for the purpose of determining whether or not the decision made by the DSSIP would have constituted Wednesbury unreasonableness? So let me repeat that. Would it actually be correct for the purposes of determining whether or not judicial review is available to look into the factual circumstances behind the allegations of sexual harassment in order to determine whether or not the decision of the DSSIP constitutes Wednesbury unreasonableness? And that is related to that question of whether or not we can actually kind of look into the merits of the decision or the factual circumstances that led to a decision being made in the first place. In other words, is Wednesbury unreasonableness limited solely to the question of the legality of the decision? And when we say legality, does legality actually mean that you can't look at the factual circumstances in which the decision was made?
I think it's the fact that they're not supposed to look at the facts, but if there has been a wrong conclusion drawn from the facts, so really the facts only indicate that there's only one possible outcome, that's when they can look at the facts, that the outcome was actually so absurd. I think that's the point.
But when you say that the outcome is so absurd, it's based on what? How can you arrive at a conclusion that the outcome is so absurd? Is it by looking at what the law provides, or do you actually examine the factual scenario that led to the decision?
Well, I'm not too sure on that, to be honest. I mean, the fact that there isn't a whole lot of case law, it doesn't really help you. Like, you've got these broad principles of that no reasonable person could ever come to that decision. It was unreasonable. Well, what is unreasonable? And do they look at everything? But the fact that you've got guidance saying, no, they're not supposed to look at the merits of the decision, well, that's a guide.
Okay. So we know that as far as judicial review is concerned, the judicial review is not meant to look at the merits of a decision. We know that as a general proposition, because the law only looks at the legality or lawfulness of a decision. But when we say, when you actually look, when we try to analyze the notion of the lawfulness of a decision, what exactly does it mean? Does it mean that we're looking at, yeah, what's that?
Oh, sorry, Manjo. It's Libby.
Yes.
My understanding was that in regards to Wednesbury unreasonableness,
yes,
rather than necessarily examining just the facts, there may be an inquiry into the evidence of the existence of the fact. And if it could be proven that there was a complete lack of evidence of the fact, then that fact is deemed not to have been in existence. And then if that was a critical part of the decision, a critical fact in making the decision, that would then go to the decision being vitiated on the basis of Wednesbury unreasonableness.
Okay. Let's focus on that point first. Is Wednesbury unreasonableness synonymous with a total absence of evidence? Is that what we're saying? So what if there is no total absence of evidence? There is in fact some evidence that supports a decision. If there is some evidence that supports a decision, would it therefore mean that you can't have Wednesbury unreasonableness in the decision? And of course, that's a different question from the one that I proposed earlier. But let's just examine that. Are they one and the same? So when you say Wednesbury unreasonableness, are you equating Wednesbury unreasonableness with a total lack of evidence? Or are those distinct grounds of judicial review? And of course, you should have noticed by now that we're dealing with a lot of concepts here. So it could get quite confusing. But we're going to go back to these concepts in a short while. But because these are being raised and we're trying to understand the notion of Wednesbury unreasonableness, I think it's only relevant that we look at questions of illogicality, we look at questions of evidence, we look at the question of, merit and so on, but we will end up with an answer in a short while. So because obviously there's an overlap. So let me go back to that question. Is Wednesbury unreasonableness the same as a lack or absence of evidence? Or are those two distinct grounds for judicial review?
Wouldn't they be separate, like it's different grounds of, because lack of evidence is, we talked about that last week actually.
Yes.
And I can't remember what it was exactly, but I'm sure it's an error of law if there's lack of evidence.
Yes. So we can accept as a basic proposition that Wednesbury unreasonableness is not synonymous with an absence of evidence. So in other words, those are two distinct grounds. Those are two distinct grounds. But the question I have is, what was that? Did someone want to make a point?
Oh, it was Maggie.
Maggie, yes.
Can you hear me all right?
I could hear you well. Yes, Maggie.
Okay. I just wanted to say that with regards to the evidence, wouldn't it just be the matter of the processes and reasoning around the evidence? So if it was logical, if it was rational, and reasonable minds, came to the same conclusion, that's the issue with regards to the evidence, because you can only go on the facts that you've been given. You can't sort of make up or delve into the evidence that you don't have.
Okay, any comment to what Maggie has just said? That as far as judicial review is concerned, it is always about looking at the process of reasoning by the executive. So that the implicit assumption there is that really you can't look at the merits or the evidence that supports a decision. Is that a correct proposition? And that brings us back to that question that as far as Wednesbury unreasonableness is concerned, you really can't examine the merits of a decision or the factual circumstances or the evidence that led to the decision. Is that correct? Or does Wednesbury unreasonableness actually allow you to examine, in a sense, the merits of a decision so that you would like to determine whether or not the factual evidence supports the decision?
There was a case, Manjo, Minister for Immigration and Multicultural Affairs, that said that unreasonableness is a protean concept. That in itself sort of indicates that it changes depending on the facts of the case. So therefore you do have to analyse the facts of the case in order to ascertain if something is unreasonable.
And Manjo?
Yes, Brad.
Brad, there's also that case, it's Prasad and the Minister for Immigration and Ethnic Affairs. Now, in that case, the court held that to proceed to a decision without making any attempt to obtain the information may properly be described as an exercise of the decision-making power in a manner so unreasonable that no reasonable person would have so exercised it. So that would tell me that they can look at the evidence of the case in coming to their determination of whether the end result is unreasonable or not.
Very good.
So, I agree. Yes. My point was that you couldn't just discuss facts that aren't there. You can only make those assumptions on the facts that you've been given.
Okay, so let's begin by that point so far stated by Brad, which is really correct. Okay, that's the correct point. As far as Wednesbury unreasonableness is concerned, it does allow the court to kind of examine the evidence that it's meant to support a decision. And when I say that, we're not really saying that there has to be a total absence of evidence in order to say that the decision is unlawful. The point being that even if there's evidence that seems to support a decision, there might still be a finding by a court that the decision meets the standard of Wednesbury Unreasonableness. Now, but the question I ask is, does it mean, therefore, that as far as judicial review is concerned, judicial review actually involves an examination of the merits of a decision or an examination of the evidence that is meant to support a decision? Is that what it means? So does it mean, therefore, that judicial review can actually examine the merits of a decision?
Maybe examine the merits, but not decide on them as a merits review, merely decide if there's more than one outcome available and then not decide between those outcomes.
Okay. Brad was saying merits of evidence. So does it mean that judicial review involves an examination of the merits of the evidence? Are we saying it involves an examination of whether or not the evidence was correctly appreciated? It looks at the probative value of evidence. Is that what judicial review would entail if the ground for the judicial review is Wednesbury Unreasonableness? So going back to that question, sorry, Sarah, can you just repeat your point there? Whether or not judicial review actually entails an examination of the merits of a decision. Because that's what seems to, the notion of Wednesbury Unreasonableness seems to suggest.
Yes, but that's Manjo. Manjo, under a judicial review, they only focus on legality or the lawfulness of the administrative decisions, so not on their merits. Now that's from Pico Wallsend. And you've got Attorney General and Quinn, and the merits of the administrative decisions, which are for the repository of the executive, and that for repository alone, not for the judiciary. So on those two cases, they can't delve into the merits of the case. But however, when they look at the unreasonableness of the decision, they then go back to the merits of the case to see whether those the merits have drawn the conclusion of unreasonableness. So yes, they can look at it, but not to circumvent the executive's power in making the original decision.
So how do you distinguish it? It seems to me they're one and the same. Or is that prediction?
Oh, well, I don't know. Unless I've totally confused myself and everyone else, they are different. They can't superimpose the judicial their view and the determination over the executive's determination, because that's their job. And Mason has clearly defined that the court's role is not to stand on the executive's authority.
Yes.
They can only, they're like the umpire in the rules that the authority have used. So in looking at the rules, in this case the law, has the executive gone outside those rules in coming to their conclusion? But to do that, they have to look at the merits of the case in addition to everything else in coming to their determination on whether the final decision was unreasonable.
So where does that leave us, Brad?
Brad.
With a headache.
Which Brad?
Sorry, Brad Marler.
Okay.
Oh, it leaves us, as Vivian has just put in the chat box, it's left us confused. Because there is a line, but it's not a clear line. It's a broad line.
Is that really the case?
The area is grey.
Manjo, my feeling...
Brad Corby, before I say that, Audrey, you have a point there in the chat box. Sorry, but I can't read it. I'm having a hard time listening to what's being said here and reading the chat box. If I want to say something, you're going to have to use the mic, because I can't use my minds, listening in and reading the chat box.
Yeah.
So, Brad, having said that, Brad, can you proceed? So I can't look at the chat box and listen to what's being said. I can, I'm not able to multitask. Maybe women can, but I can't. Brad.
Well, that's my point. Looking at the judicial review is if the decision has failed in satisfying all the elements of the law to substantiate and justify that decision, that's essentially what you're reviewing. Is it a decision?
Okay.
Am I correct?
Yeah. So Aaron is saying men can't do two things at once. And Grant is making the point that let's just get to the answer because he's totally getting lost. Okay. I think it's about time that we try to wrap this up because we had sufficient discussion. Do you agree? So we'll try to, wrap this up. I'll try to I'll attempt to provide a coherent answer. Would that be fine? Okay. So let me try to integrate all the answers and come up with a coherent explanation of what Wednesbury Unreasonableness is as a ground of judicial review, and try to distinguish that from merits review. So let's begin with the basic proposition that as far as judicial review is concerned, it examines the lawfulness or legality of an administrative decision. It does not look into the merits of a decision. When you speak of the merits of a decision, for example, you're either looking at the factual correctness of a decision. In other words, on the basis of the facts or evidence that are adduced in the case, is the decision correct? And preferableness relates, obviously, as we know, to the exercise of a discretion. So that's what the definition is of a merits of a decision. So, as we said, judicial review focuses on the legality or lawfulness of a decision. But the question is, what exactly does it mean when you say that the judicial review focuses on the legality or lawfulness of a decision? Are we just looking at the decision-making itself as we know it to be? Or are there times when you actually look at in a sense, the merits of a decision? Now, Wednesbury Unreasonableness, in a sense, is not synonymous to looking at the merits of a decision, but it does acknowledge that when a decision is made by an administrative decision maker, one, either because of a total absence of evidence or because on the basis of evidence that is there, it would be totally unreasonable for a decision maker to have arrived at a decision. We can actually say that judicial review at times can look at the evidence in that limited sense. So whereas in general we look at judicial review as examining the decision-making process only, and not into the facts or evidence of a decision, because that would pertain to merits review. In fact, judicial review in limited cases can appear to examine the factual circumstances of a decision as well as the evidence that is being adduced to support a decision. So that if there is in fact a total absence of evidence, as we already know, as we covered last week, that can be the ground for judicial review and for the invalidation or the setting aside of an administrative decision. So we already know it as a fact from what we know last week, that if there is a total absence of evidence, that will be a ground for judicial review and for a decision to be set aside or to be quashed. And that is also found in the ADJR Act. So therefore, we know that as far as judicial review is concerned, there are instances when a judicial review actually seeks, in a sense, also examines the evidence adduced or that is used to support a decision. So that's one. So if there is a total absence of evidence, we know it already as a matter of law that an administrative decision will be invalidated if there is a total absence of evidence, because if there is a total absence of evidence, that decision has got to be unlawful. Wouldn't you agree? So if you have an administrative decision that is not based on evidence, that decision has got to be unlawful. That would have to be contrary to law, because the law requires that every administrative decision must be supported by evidence. So in other words, if there is an absence of evidence, that has got to be contrary to law. Clear so far? Clear? Now, the other point is, what if you have a situation where a decision, there is evidence that supports a decision? So you can't say, therefore, that there is a total absence of evidence. What if there is some evidence that supports a decision? Would it necessarily mean that the decision is necessarily lawful and therefore beyond judicial review. And therefore, a court cannot quash a decision, an administrative decision. So now let me repeat. You have a situation where, when you look at the decision of an administrative body or an administrative agency, there is evidence that supports the decision. Would it necessarily mean that because there's evidence that supports a decision, judicial review is unlikely to be available? The answer is, even if there is evidence that seems to support a decision, the question will always be, on the basis of the evidence, can it be agreed that reasonable persons will only arrive at a single decision? Because if it can be said that reasonable minds or reasonable authorities will only arrive at a particular decision, and yet this administrative decision maker arrived at a different decision, then you might say that there is Wednesbury unreasonableness as far as the decision is concerned. Okay? So the only time, therefore, you can say that there is Wednesbury unreasonableness is when, if you look at reasonable authorities or reasonable agencies, they can only arrive at a single decision. So in other words, if there is a possibility that reasonable authorities can have a disagreement as to what the decision can be, there will never be Wednesbury unreasonableness. Okay? Now, on the other hand, if you can say that that reasonable authorities are meant to arrive at, this kind of decision, at a singular decision, and yet you have another decision maker who is arriving at a decision that is totally different. You might then argue or say that that person, that decision would have met the standard of Wednesbury unreasonableness. But in that case, you're kind of looking as well at the evidence behind the decision. Are we clear so far? Did that make sense? So, as far as what Libby said, if there's only one possible reasonable decision, so the significance of that would be that if there's only one possible reasonable decision and yet the decision maker arrived at a decision that is different from that would meet Wednesbury, the standard of Wednesbury unreasonableness. Okay, so if there is only one possible reasonable decision from reasonable authorities, not from the viewpoint of a judge, and yet there is this decision maker who arrived at a distinct decision, then you can argue that that decision meets the standard of Wednesbury unreasonableness. But on the other hand, if it is possible for different decision makers to actually arrive at multiple decisions, then it's difficult to argue that the standard of Wednesbury unreasonableness will ever be met, because it is subject to multiple interpretations or multiple decisions. Clear so far? Now, and I'm going to go back to the notion of joke versus, a joke versus what is being handled in a short while. So going back to so that's why it's really successful, because for there to be, as pointed out by B, Wednesbury unreasonableness is really successful because it's really difficult to say that on the basis of the facts, there's only one possible decision. Because the moment you can say that different administrative decision makers can have multiple decisions, Wednesbury unreasonableness is automatically foreclosed. Now, so as pointed out by Audrey, the high standard would have to be very absurd. So going back to the case facts now, to the scenario that we have, given the fact that it was open to an administrative decision maker to either dismiss or to suspend Mr. James, so in other words, reasonable decision makers can disagree as to what the proper penalty should be, then in that case, it would be difficult for there to be an assertion that there is Wednesbury unreasonableness. Do you get me so far? So if on the basis of evidence, it was open to an administrative decision maker to arrive at the decision, whether he will impose a penalty of suspension or a penalty of a reprimand or a penalty of dismissal. if reasonable decision makers can arrive at multiple decisions, in that case, it will be very difficult to assert Wednesbury unreasonableness of the decision. And therefore, in that case, judicial review is likely to be unavailable. So do we get that so far? So under the facts, it would be difficult for judicial review to be available on the ground of Wednesbury unreasonableness, because Wednesbury unreasonableness would only happen when the decision is so absurd that there is no sensible agency that could arrive at that decision. But if it is possible to say that a reasonable agency could arrive at that decision of a dismissal, then the standard of Wednesbury unreasonableness would not have been met. Clear so far? Now, let me go back to that point about the joke versus being manhandled, because we had already admitted earlier that there are gradations or different kinds of sexual harassment. One can be a simple sexually oriented joke, as opposed to an instance when somebody actually manhandles a woman. Now, let us assume that if you look at the facts, what Mr. James was responsible for was actually to have made a sexually oriented joke, because the facts are silent. So which is why B is actually correct earlier in saying, why are we even looking at the evidence? Okay, so we should have made the assumption actually that this was a situation where it was open on the evidence for the DSSIP to actually dismiss it. We're simply making an assumption that the act was serious enough to warrant a dismissal. We're making that assumption. Now, however, what I'd like to do now is to backtrack a bit and make an assumption that the act involved was actually a sexually oriented joke. Okay, so let's assume that the act of sexual harassment involved a sexually oriented joke perpetrated by Mr. James towards the lady. I forgot her name now. And let's assume that on the basis of a sexually oriented joke, the penalty that was imposed on Mr. James was still dismissal. Okay, the question is it possible to argue that Wednesbury unreasonableness could have applied in that instance, assuming that the actual act that was perpetrated by Mr. James was actually a sexually oriented joke? Would judicial review be available? Okay, let's not talk about merit review. I'm just asking a question, judicial review only. Assuming that what was involved was a sexually oriented joke, and we'll even say that it's not a, I don't know if there are gradations again about sexually oriented jokes, but it's not as obnoxious. There are different kinds of sexually oriented jokes. Some are very obnoxious, some are less so. So let's assume that it is a less obnoxious sexually oriented joke. The question I'd like to ask is, from the viewpoint of judicial review, do you think judicial review would be available? Thinking about the notion of Wednesbury unreasonableness, where the rule is that you can only have Wednesbury unreasonableness if the decision is so absurd that no sensible person could arrive at that decision.
Well, I would argue yes, Manjo.
Clarify yes, Brad, because the question was so broad, I don't know what yes means.
Yes, that Mr. James would be able to pursue judicial review on the basis of unreasonableness. And I go back to Prasad and Minister for Immigration and Ethnic Affairs.
Mm. Okay, judicial review would be available, yes, but would the application most likely prosper or not?
Well, if I was working for Mr. James, I would like to think yes, it would. Because it is unreasonable for him to be fired or, to be sacked or whatever happens to him, because that's an extreme punishment based on a joke.
Okay, hold on. That was a different thing you said, Brad, because you said that decision was unreasonable. Is that the same as Wednesbury unreasonableness?
Yes.
Those are actually two different things.
Are they? Why is that?
Yeah.
Please explain.
Yes, I will. In a short while. Brad Corby, you raised your hand. Yeah, that's
Manjo,
right. Just be careful with the word reasonable. Yes, Brad Corby.
Yeah, in reading that last sentence,
yes,
my question is, it says, given that it was open to the DSSIP to impose a penalty such as a suspension, so what Mr. James is saying, that their decision was totally unreasonable and irrational because it imposed a penalty dismissal.
Yes.
Now, so the question beckons, did they have the power to dismiss, or did the DSSIP only have the ability to impose a penalty up to a suspension?
We assume they have the power, but they have the power to impose.
Okay, we're assuming they can.
They can.
So I was just reading that point as to what Mr. James has said, and he's sort of asserting that they've gone beyond their power.
Okay. Now, before we proceed further, just to make sure, let's just backtrack a bit, just so people don't get confused. Okay. In relation to the question to the original, as an answer to the original question, the original answer really is that the decision would not meet the Wednesbury Unreasonable standard of judicial review. That's already a given. Okay, we're making the assumption that on the basis of the facts that were available before the DSSIP, we're making the assumption that it was open to them to impose dismissal or suspension or a reprimand. And because it was open to them to impose any of these penalties, we're saying that the standard of Wednesbury Unreasonableness would not have been met. However, we're kind of changing the facts this time because this has been raised. We're making the assumption now that when you look at the evidence seems to be that what the allegation was involves I can't say innocent, but a less obnoxious sexually oriented joke, which is still sexual harassment. But the question is, if that were true, can it be argued that if the penalty were dismissal, that penalty of dismissal would constitute Wednesbury Unreasonableness? That is the question now.
No, because it can still be argued by somebody that even an inoffensive joke is the beginning point or the starting point for more serious sexual harassment, and therefore there is the possibility that somebody can argue that he should have been dismissed. Whether it's right or not, that's an argument for a merits review. So given that there's two possibilities, it's not open to judicial review. It's only open to judicial review or Wednesbury Unreasonableness if there's one conclusion open on the evidence and the decision maker does not come to that conclusion.
Okay, let me just provide an answer for now because we're kind of running out of time. Although I don't mind extending the time of for this tutorial. I would like to make an argument. I am making the argument that if it was a less obnoxious or not a very obnoxious sexually oriented joke, although it would have constituted sexual harassment, I would argue that a decision involving dismissal of Mr. James on the basis of that not very obnoxious sexually oriented joke would meet the standard of Wednesbury Unreasonableness. And my reason for that is that I would argue that any sensible person or agency are likely not to have imposed a penalty of dismissal under that particular fact. So I'm making the argument that if the act of sexual harassment perpetrated by Mr. James had involved a not very obnoxious sexually oriented joke, I would argue that sensible persons and agencies are unlikely to arrive at a penalty of dismissal. In fact, they are unlikely, that the most that they would probably do will be a reprimand or suspension, but never dismissal. So if I'm making that argument, I'm therefore saying that that a decision where involving dismissal under the facts would have constituted Wednesbury Unreasonableness. And I say that in relation to what Brad Marler said. The notion, when I said Wednesbury Unreasonableness, it's not because it seems to be unreasonable from a layman's point of view, but it is unreasonable because if you were to bring, this factual scenario before various original decision makers, they are most likely to agree that dismissal would be unreasonable as a penalty. They would have likely agreed that the kind of penalty that should be imposed would have to be something short of a dismissal. Okay? So in that sense, as Jacob pointed out, it's possible to argue that if what is involved is just a sexually oriented joke, and then you end up dismissing a person, it can be argued that that's a very capricious use of power. It can't be justified. And you can go back to the case of Edelstein versus Wilcox, where when the commissioner of taxation used his powers, he had the option of either just giving a warning to Edelstein, or he had the power to actually garnish all his funds. And when the commissioner of taxation used his power, what he did instead was to garnish the funds, which made it difficult for Dr. Edelstein to proceed with his business. That was found by the court to involve the exercise of a capricious use of power, which was equivalent to Wednesbury Unreasonableness. Okay, so having said that, we will notice, therefore, that as far as Wednesbury Unreasonableness is concerned as a ground of judicial review, it does kind of touch upon the factual circumstances that leads to a decision. Not really the factuals, it does touch upon the evidence, but it is not synonymous as a merits review. Because it's not a question of weighing of evidence or looking at the purported value of the evidence. It's always a question of, on the basis of this evidence, what would be, potential decisions that reasonable or sensible persons or sensible decision makers could arrive at. Did somebody try to raise a point?
I was just Margie.
Yes,
I was just going to say, so it goes back to what I was originally saying about the evidence issue, in that because it doesn't say clearly what he actually did, then you have to make assumptions and say the correct way to answer this would be to say, well, if it was a simply crude joke, then you would perhaps pursue unreasonableness. However, if it was groping the woman or whatever, it all comes back to the facts that you're given.
Yeah, but to me, the simple answer would have been to just say that it would be difficult to impugn the decision as meeting the Wednesbury Unreasonable standard. That would have been the simple answer.
Yeah, and that's what I think.
I don't want to complicate it. I mean, if I were, if there was a test, I'd simply say that it's difficult to meet the Wednesbury Unreasonable standard. The only reason why we're talking about, this nuance is because this had been raised. But in general, we can simply assume that, there was enough basis for the DSSIP to arrive at a decision of imposing a penalty. Because if there had been a basis for them to impose the penalty of dismissal, that's the end of the story. You can't have Wednesbury Unreasonableness.
Yeah.
Okay.
Thank you. Very clear.
Sorry, Manjo. It's
Yes.
Grant. So would the court not listen to his judicial review? Because if I was Mr. James, you'd do everything possible to argue that it was an unreasonable decision. So you'd want to face the review and let the judicial review come back to that. But then make the decision that there was no unreasonableness to you. I'd be going all out.
Sorry, Grant, I didn't really follow that. Can you say that again?
Well, I'm sort of saying to you, you're saying there is no judicial review for Mr. James because of that. Yet we've sort of argued that if you were Mr. James, well, I'd be arguing that the guy was an imbecile, or it was the lady that made the decision and she was unreasonable. I'm going to take it as far as I can go. Would the court say, well, bad luck, we're not even going to listen to you?
Yeah, the answer, my answer would have been that simply that the decision would not meet the Wednesbury's reasonable standard of judicial review. That's the answer. In other words, I mean, there's nothing stopping a person from filing an application for judicial review. All I'm saying is it's unlikely going to be successful. It's unlikely to be successful because it is unlikely to meet the standard of Wednesbury Unreasonableness, which is different from whether or not he can apply. Of course he can apply. He can always claim that the decision meets the standard of Wednesbury Unreasonableness, but that it's unlikely for that application to prosper. So which is why the answer is the decision would not meet the Wednesbury Unreasonable standard of judicial review. And I would leave it at that and explain why it wouldn't, because it can be argued that it's difficult to say that the decision would be so absurd that no sensible person or agency could arrive at the decision. Because if, in fact, it's any sensible person or agency could arrive at the decision imposing penalty, the penalty of dismissal, that's the end of the story. Yeah, that's the point, Peter. So I'm not asking a question of whether or not he has a chance at JR. That's whether or not he could file an application for judicial review. Of course he can, but it's likely going to be unsuccessful. Okay, let's move on to the next question then. So I don't mind extending the time. Oh boy, it's meant to pick up my daughter. Okay, let's do this quickly. Can I get somebody to volunteer to read this question for us? Volunteer?
It's Vivian.
Vivian,
after finishing the Diploma of Community Services work at the Good Technical Institute, Sherlock Gordon applied for a social support worker's licence in the Australian Department of Social Services, DSS. The Social Support Workers Act, Commonwealth, requires anyone seeking to practice as a social support worker to obtain a licence from the DSS and to meet requirements as to moral fitness. Gordon submitted all the requirements, including a police clearance that stated that he has no record of any criminal conviction. The DSS, however, received an anonymous call saying Gordon had been the subject of a police investigation for child molestation in 2005. That investigation had even been covered in the news at the time. Because of the unwillingness of any witnesses to come forward, the investigation was subsequently had been terminated. Gordon was later informed by the DSS that it had concerns about his moral fitness because of the complaint against him for child molestation in 2005 and hence could not issue him a social support worker's licence. He has come to you as a solicitor for advice. Advise Gordon on whether he can apply for judicial review on the ground the DSS decision was unreasonable.
Thank you, Vivian. Can I get everyone to post his or answer quickly in the chat box? Mm-hmm. So some are saying you can apply for, you would advise to apply for judicial review. Some are saying not likely to succeed. I'd like to listen to those who are saying that you would advise that judicial review is something that Gordon should apply for. Can I get the proponents of those who are likely to advise Gordon that judicial review should be pursued? Why is that? Or for that matter, somebody who says, one of those who says that he shouldn't apply for judicial review. Can I get someone to speak up?
It's Margie here. I said yes because I thought they were probably taking information into consideration that was irrelevant.
Okay, what is irrelevant there? The fact that it was never proven? Would that make the evidence irrelevant? Is that what?
The claim, I would say, because there's no evidence. He hasn't been convicted of a crime.
It wasn't even charged.
There's been an allegation made, but no one came forward. The fact that there was an allegation is grounds enough to consider. I went the other way, Margie, and I said, look, there was a statutory discretion and to decide whether he was morally fit, and they had that discretion, and it's not for a judge to question that discretion. There was evidence 10 years ago, there was an allegation. Look, they've exercised that discretion. I don't think it met that standard. But I think you could also argue the other way. So
yeah,
those
I
are
agree.
things there.
I argued because I felt that it was a judicial review on the process of the decision, as in they decided that he couldn't be accepted on moral grounds, but did they do that in considering material that wasn't relevant?
Okay, but Maggie, going back to your point, why do you say that the evidence is not relevant? Which evidence is not relevant here?
Well, if they didn't have any strong evidence, like a conviction or any evidence from a witness to say that, he actually committed an offence.
Okay. So you're not using the phrase strong evidence. Are you admitting that there is in fact evidence, except that it is not strong?
No, I'm really referring to criminal conviction, I guess.
Okay. But was there a requirement under the law that there should have been a criminal conviction? The point seems to be that the DSS did not issue the certificate of moral fitness solely on the basis of an anonymous call. Even if there had been no criminal conviction. So that seems to be the evidence. That seems to be there is a basis for the decision not to issue the license. So the license was...
Isn't that information irrelevant?
Okay. What exactly does the notion of relevance mean here? We're not taking up civil procedure evidence here, but what exactly does the legal terminology about evidence mean? What does it signify? Yeah, so relevance simply is it possible to prove or disprove a fact? For as long as, so we're not talking about the probative value here. The simple question is, does this evidence lead to a fact being proved or not proved? So obviously, therefore, the anonymous call can prove the fact. It just might be weak, which is something else. So the evidence is not irrelevant. The evidence is clearly relevant. But the point is, an argument can be made that the evidence or the relevant is weak. So the question is, if the evidence seems to be weak, after all, there has been no conviction. And after all, what is involved is an anonymous call. The question is, if the DSS did not issue the license on the basis of evidence which seems to be weak, and you might even say unreliable, would that mean that as a solicitor, you're likely to suggest to Mr. Gordon that he should apply for judicial review? So in other words, does that meet the standard of Wednesbury unreasonableness?
Oh, Manjo.
Yes, Brad.
If you look at the case of Hewen and Minister for Immigration and Local Government Ethnic Affairs,
yes.
Now the court held that the decision to deny a migrant an entry visa was unreasonable because they looked at a conviction 30 years previously. So you could argue that by looking at that allegation in 2005, that they've come to a decision which is unreasonable.
Okay. You might say that the decision is unreasonable, but does the decision meet the standard of Wednesbury unreasonableness? That's the question. So in other words, if you ask that question, you're actually asking the question, is it actually open to the DSS under the facts to arrive at a decision not to issue the certificate of moral fitness? Because if you say that it is open to them under the facts not to issue the certificate of moral fitness, then the standard of Wednesbury unreasonableness cannot be met, even if you think the decision seems to be unreasonable or irrational, because they're not the same. So in other words, if it is open to the facts, if it is open on the evidence, for the DSS to arrive at a decision not to issue the certificate, meaning they based it on the anonymous call, then the Wednesbury standard of unreasonableness cannot be met. And it can certainly be argued that it was open to the DSS to take into account the anonymous call, even if that evidence seems to be weak. And we're not talking of a criminal conviction here. That evidence is relevant because it proves or disproves whether or not there was moral fitness on the part of Mr. Gordon. Even if it is weak, that is still evidence. And if the DSS chose to accept that evidence as sufficient basis for them not to issue the license because of a lack of moral fitness on the part of Mr. Gordon, then the standard of Wednesbury unreasonableness will not be met. Judicial review is likely to fail in this case. So that is the answer. So the answer is because it was open to the DSS on the basis of the anonymous call to actually not issue the license, then the standard of Wednesbury unreasonableness would not have been met. And because remember that as far as judicial review is concerned, judicial review does not examine the probative value of evidence. It doesn't examine the factual correctness of the administrative decision. It doesn't. That's not part of judicial review. So the answer here is the decision would not meet the Wednesbury standard of judicial review. Therefore, if I were the solicitor, I wouldn't advise Mr. Gordon to pursue an application for judicial review. What's that, Vivian? You get to respond.
Would he have any avenue of appeal at all?
Well, would he have judicial review? I think would likely to be ineffective. The question then is, well, he can certainly go for an internal review. That's open to him. But the second question is, and that hasn't been stated there, you can always ask whether or not perhaps under the Social Support Workers Act, perhaps a merits review is actually available under that act. We don't really know that. So but that's not part of the question. But had it been a broader question, if the broader question had been advise Gordon on what he can do, then your first answer would have been, if merits review is available under the Social Support Workers Act, then apply for merits review with the AAT, assuming that that particular law allowed for a merits review. If that had been the broader question. So if the broader question was advise Gordon on what he should do, then you will say, assuming that the Social Support Workers Act provides for a review by the AAT, then of course, that is the first remedy that he should pursue. He should apply for merits review by the AAT. Now, if that were not available because that specific act did not provide for that remedy, then you need to examine whether or not judicial review is available. But it would appear to me as a solicitor that on the facts, it's difficult to argue that judicial reviews would be available on the ground of Wednesbury unreasonableness because that decision would not meet the standard of Wednesbury unreasonableness. Okay, questions?
Thanks, Manjo.
So we're good. Okay, so thank you, everyone, and I hope to see you again next week. If you have any question, feel free to send me an email, but I need to go. I have to pick up my daughter. Okay, thank you.
Very good. Thanks, Manjo. Good night, all.
Good night.